We have some great panelists. Third-party liability for sexual misconduct, and I'll very briefly, by their request, introduce them briefly and in order that they'll be speaking. So first up is Eugene Volokh. He's the Gary T. Schwartz Distinguished Professor of Law at UCLA. And before coming to UCLA, he clerked for Sandra Day O'Connor on the U.S. Supreme Court and for Judge Alex Kaczynski on the Ninth Circuit. He's also an academic affiliate for the Mayer Brown LLP law firm, and actually everyone up here is either currently affiliated with Mayer Brown or an alumni of Mayer Brown. So Mayer Brown, very popular place to practice law among these three. Next up is Ellen Bublick, and she's the Dan B. Dobbs Professor of Law at the University of Arizona. Bublick clerked for Judge Walter Cummings on the Seventh Circuit and practiced law at Mayer Brown and Platt in Chicago before entering academia. And then third will be Gail Heriot at the University of San Diego, where she's professor of law. She clerked for Seymour Simon on the Illinois Supreme Court, and prior to entering academia, practiced with Mayer Brown and Platt in Chicago as well. So with that, we'll hand it off to Gene.
Thank you very much. I almost never matters the chair that I hold at the law school at UCLA, but in this case it's the Gary T. Schwartz chair. And Gary was my torts professor back in the day, some years before his untimely death. He's a great scholar of torts, and inspired by his example for about 5 years actually I taught torts. It's not my main field the way that it is Ellen's, who also holds a chair after someone even more noteworthy in the field of torts and I think remedies. But it's an area that I've found very interesting and I found very enlightening to teach. And I'm not sure why my PowerPoints aren't coming up. When talk turned to discussing the Title IX debate, and the question of what universities should do with regard to allegations of sexual misconduct by students, I was reminded of the broader questions that arise with regard to this when it comes to tort law. The Title IX approach to things looks very odd, and may in fact have some really serious problems to it if you just look at it from the perspective of universities. Why are universities all of a sudden being asked to undertake these investigations and being asked to undertake some duty to students for what are after all crimes? Why not leave it to criminal law? And that may still be the right approach, but it turns out that that's not the approach that historically had been taken in many areas of tort law. I will say, I don't quite understand why this isn't a PowerPoint presentation, because I wish I could sequence it the way it's going through PowerPoint. Is it possible to do this as a PowerPoint rather than a PDF? Okay, well, then I think it's probably too late. So never mind. Pretend I didn't say that. And now the only thing I need to figure out is how to maximize it again. Is it view? Yeah. Okay. Full screen mode, maybe. Control-Alt? Okay. All right. Well, actually, this does look a little bit better. So the title of this talk is Duties to Protect, Investigate, and Expel. And you'll notice duty is, of course, a tort law concept. When we hear about duties, we often think about tort law. If you look at tort law, there's a wide range of areas where private parties are being asked to do the same sort of third-party policing you might think about it in a certain way, but tort law views it as a familiar form of duty to reasonably protect, including in allegations of criminal misconduct. So the classic and most established example, long before the tort law revolution, say, of the 1950s and 60s, to the extent that there was more like 1960s and 70s, is rules having to do with negligent hiring, negligent retention, negligent supervision of employees. So if somebody sends an employee into your home, let's say a door-to-door salesperson, or even outside that, if you're driving down the street and somebody hits you in their car, the employer might be liable. Now, in some situations, that's done under respondeat superior on a strict liability basis. But not when it's sort of, at least in most states, the rule is when the person is off on a frolic and detour of their own, serving only their own interest, as would be almost always the case with criminal attacks and especially sexual attacks. But that doesn't mean the employer is entirely off the hook. The employer may be liable on a negligent hiring, as I said, retention or supervision theory. So if, for example, an employer is told, oh, your employee either sexually assaulted me or tried to, or for that matter, non-sexually assaulted me. Your employee got mad at me and tried to beat me up. Then the employer, as part of its duty to protect future customers, had better look into the matter and, as we'll get to shortly, will need to dismiss the employee or else face possible liability for negligent retention. The same thing is true with regard to business visitors, protection from criminals. We know, and this is something that ended up being much more common starting with the 1960s, we know that companies, let's say shopping malls, have a duty to protect customers from criminal attack. Likewise, landlords have duty to protect their tenants. That often comes up with a general duty to try to institute some sort of reasonable security measures against the public at large. But certainly if a business visitor is told, if a business is told, look, one of your employees or another visitor who's habitually a visitor to you has tried to attack me, then the duty to reasonably protect would mean that the employer would have to investigate this. And perhaps kick out the visitor, stop allowing this dangerous visitor from coming. Likewise, there's even essentially court claims for wrongful failure to evict that some courts have accepted. That if a landlord knows that tenants are posing a danger to co-tenants, then the landlord has a duty to protect the co-tenants. So those are standard tort law duties. The employee duties are very common. The other ones are somewhat more exotic. They come up more rarely, but there are cases for each one. Even neighbors, there may be a duty to protect neighbors. The landlord has protect neighbors from its tenants, and the theory is that the landlord, by allowing dangerous tenants onto its property, is just creating a risk, and if it's unreasonably doing so, that has to stop. Now, it turns out that Title VII also imposes duties to protect employees from co-workers and to protect employees from visitors as well. And those are actually very closely analogous to the Title IX duties, unsurprisingly, because Title IX is built on the same doctrine. But again, they're not that different from the tort law duties. Now, you'll see in many cases, especially for things like wrongful failure to evict, there's a California Supreme Court case sharply limiting that. But the way that courts tend to limit those duties is by saying that the duty only kicks in when there's a very high degree of foreseeability. That a landlord doesn't have to be constantly investigating what all of its tenants are doing in order to see maybe it should evict one of them. Because among other things, it'll be very burdensome on the employer, but on the landlord, but also might pose privacy concerns and such. But once there's an accusation that an employee, a habitual visitor, a tenant, is posing some risk to people because this person has already attacked someone before, then that foreseeability requirement is amply met, especially if the attack has been a serious attack. Maybe it's not met if the person has just been cursing at a co-tenant and then turns around and physically attacks him. But once there is a physical attack or an allegation of physical attack, then the employer is on notice. And unsurprisingly, and I've already implied this, duties to protect involve duties to reasonably investigate, right? It's not that it has to be, there's a strict liability basis. That's definitely not so. It's not like the employer has to take, or a landlord has to take all possible steps to protect people. But once there's an allegation, it's failing in its duty of reasonable care by failing to reasonably investigate it. So, for example, first one is an employer case. School district may be held liable for failing to adequately investigate a complaint and continue to employ a teacher. Note, it is not when we say duties to reasonably investigate, it's not a freestanding duty that the lawsuit is you failed to investigate. Rather, the lawsuit is you failed to, if there's a later attack, you're responsible for this attack because you could have avoided it through reasonable investigation. Likewise, a duty to evict, with the same footnote, may arise where the landlord knows of a specific threat the one tenant poses to another, or there's a history of violence by one tenant against other tenants. So it's pretty well established. Maybe it's a mistake, but it's certainly out there. And one thing that's pretty clear to me, I don't have any cases on this point, but I think this is just the way the logic of tort law, which operates in preponderance standards all the time. One thing pretty clear to me is that if an employer says, look, we did an investigation, there was only a 2/3 chance that the employee had sexually abused the client, so we didn't fire him. I don't think the employer is going to get very far if the employee does it again, and then there's a lawsuit against the employer for negligent retention. Likewise, if the employer just says, you know, the guy was tried, but he was acquitted because there wasn't proof beyond a reasonable doubt, I don't think that's enough. Again, the duties imposed by tort law are generally duties that are enforceable under a preponderance of the evidence standard. It seems that the reasonable care on the employer's part has to do with reasonable investigation. Maybe it doesn't have to fire anybody who's ever been accused. Maybe that would be unreasonable, at least an unreasonable demand of an employer. But I doubt that an employer, as I said, would get far with saying, no, we insist on proof beyond a reasonable doubt, or we insist on clear and convincing evidence, or we insist on a criminal conviction before we fire somebody. Now, what are the costs of these duties? And I think there are real costs. One is the risk of third parties erring on the side of firing or eviction or expulsion. That if the third party, whether it's a college in Title IX or an employer or a landlord or whoever else, if the third party knows that it will be on the hook for possibly massive damages if they fail to take steps, but not on the hook for much if they evict somebody or expel them or fire them because it's essentially at-will employment or their equivalents in the other areas, then an employer might over-enforce. The third party might over-enforce. Now, there are real costs in terms of morale, in terms of search costs and other things in firing an employee unnecessarily, in evicting a tenant unnecessarily. I'm a landlord. I certainly don't want to evict tenants who are paying good money unless I have to. But there might very well be this kind of disproportional over-incentive, over-deterrence. Another thing is a deterrent to giving people a second chance. In a lot of these situations, the classic example is just in negligent hiring. Once somebody has a criminal record, then at that point the employer may be negligent in hiring him in the first place, even if the person has served out his time. Now, you know, second chance is an interesting metaphor because second chance sounds good, like second chance to do right. But there's also, if there's a chance that you're going to do right, there's a chance you're going to do wrong, right? Because maybe the employer, maybe the university, maybe the landlord giving someone a second chance means that we're acknowledging that there's a chance that the person will attack someone, and then that innocent person bears the cost of that second chance. Nonetheless, especially as people are identifying the fact that, you know, some people do bad things, but, you know, especially once they get out of jail, we want them to have a place to live. We want them to have a job. We want them to have an education. We want them to have a stake in continued clean living, or else they might be more likely to repeat their offense. The other possibility is that increasingly, especially with the presence of easily accessible record information and such, it's not just loss of one opportunity, but of an entire career. That if somebody is expelled from a university and, let's say, applies to another university, presumably the other university may get this information, may ask, you know, did you take some other classes? What happened to you then and such? And interestingly, there is one area where we do require proof beyond, by more than just preponderance of the evidence, clear and convincing evidence, and that's for loss of professional license. As I understand it in most states, if you're going to be stripped of your bar card, if you're going to be disbarred, if you're going to be stripped of your medical license, that requires proof by clear and convincing evidence. So I think the strongest argument I've seen for some higher standard in Title IX has to do with that. That basically, if you're kicked out of one school, Mind you, not if you're just suspended perhaps, or admonished or reprimanded, but if you're actually kicked out, and it means that you're going to have a really hard time getting an education at other schools, maybe the consequence will be something comparable to a loss of your entire opportunity for professional employment, and therefore the burden ought to be higher before you're kicked out. But again, I doubt that that's so, even if, for example, in a negligent retention context, you're being fired from some job may really affect your career for the future, because future employers will know the same. Again, I doubt that that's going to be reason enough to justify an employer retaining you when there's a merely 65% chance that you're out there molesting customers. So that's why I think this is all a very difficult question. I don't quite know what the right answer is, but I thought I'd point out some of these analogies because I hadn't seen them much talked about in the Title IX debates.
Thank you so much for including me and for including this important topic in the schedule. In my time today, I want to briefly address three different issues. First, to look at some data from appellate courts about tort actions brought by sexual assault victims. Second, to look at some recent issues in these cases in the state Supreme Courts, and then finally to offer some reflections. In terms of data, about 10 years ago, I wrote an article about tort cases brought by sexual assault victims, and I just looked at state appellate court cases, and my sense at the time was that the numbers of these cases were really increasing quite dramatically. And you can see from this chart that the investigation that I undertook bore this out. In 1970 to 1975, there were only about 7 state Supreme Court cases addressing sexual assault claims by victims in tort cases. A similar number for state appellate courts. And then by 2000 to 2005, there were 110 state Supreme Court cases addressing the issue and 200 appellate court cases. And this is a trend that was really national. There are 47 of 50 states that had opinions during this second time period. And this is not just due to an increase in opinions during the time period. In fact, the number of Supreme Court opinions during the later time period generally declined. So this seems to be an actual increase, at least at the appellate level. And it's been a decade since I undertook that research, and so I thought for this talk, let's take a fresh look and see what's going on in the last 5 years. And having done that, you can see that there's still much higher levels, more similar to the 2000 period than the 1970s period, but it's about 20–25% fewer cases. So perhaps we the number of cases is waning again. And let me tell you a little bit about not just the number of cases, but also the character of the cases. It was thought for a while that the civil cases were going to be a substitute for the criminal actions because there was a lesser standard of proof, victims could bring these directly and so forth. The cases that I've read, it's fairly rare for these to be a direct substitute for a criminal action. Much more frequently, we're looking at the responsibility of third parties, schools, bus services, foster parents, hospitals, and so on. One of the things that surprised me a lot when I started to do this research, and then I was surprised that I was surprised, was how vulnerable so many of the victims in the cases were. Children, the disabled, the infirm, the institutionalized are really heavily overrepresented in these cases. And there was also a thought that maybe these are the he said, she said kinds of rapes that are going to be in this data set. But actually, there's a real overrepresentation of documented, corroborated rapes where assailants were jailed, and where there was other kinds of evidence. So I think it would be fair to say that the criminal law is largely, but not exclusively, looking at the responsibility of assailants, and the tort cases are largely, though not exclusively, looking at the responsibilities of third parties. In 2006, when I looked at these cases, the four main issues that I saw in this docket were issues about the extent and nature of third-party responsibility. So does the foster placement agency have to tell the foster parents about the history of the child that they're placing in terms of sexual assault, the appropriate measure of damages, and division of responsibility for damages. So what's appropriate compensation for something like rape or fondling? For division of responsibility, we have now in torts, in many jurisdictions, comparative apportionment that divides responsibility between intentional tortfeasors, negligent tortfeasors, and the victim. So my colleague Dan Dobbs says we now compare everything from murder to bad table manners, and how do we figure out who's responsible for what? Availability of compensation mechanisms such as insurance are hugely important because intentional torts can't be insured. And then the protection of privacy within and through the civil process of party interest, particularly privacy and confidentiality and so on. Looking at the 2017 cases, actually the issues were quite different. The main issue that I noticed immediately that's in 7 of the 16 state Supreme Court cases from last year is how does this law interact with different bodies of law? And so the question is, when you sign a lease that says you'll arbitrate all issues, if you get raped in the parking lot and you sue for premises liability, is that something that you have to arbitrate? Or the case below in Texas where a woman is sexually assaulted by her employer at work on one occasion, and the courts below had said, well, maybe this is preempted by Texas's Human Rights Act, but the state Supreme Court said, no, you still have your common law assault claim. The other issue that really popped out from these cases is the liability of employers, or what I'm terming loosely guardians, maybe not formally to the level of guardianship. And here, the key question is, in many of these cases, do you have actual knowledge of prior assaults by the employee? So the Goldstein case from Georgia, dental practice didn't have appropriate permits to administer anesthesia or to hire people who administer anesthesia. They hired an anesthesiologist who kept the patient under anesthesia for 2 hours, part of that time sexually assaulting her. The anesthesiologist documented that sexual assault. He had videos on his phone. And the patient sued the dental practice. A jury found for the victim, but the Georgia Supreme Court, as a matter of law, said even though the dental agency wasn't permitted to provide anesthesia, nevertheless, they had no knowledge of prior assaults by that anesthesiologist, and so couldn't be liable. Also, given this importance of prior sexual assaults, factual issues surrounding knowledge of sexual assaults has been the subject of a lot of litigation. What discovery can you get about it? When can those issues go to the jury? And I think, I'm sorry I made this last set so small because it's maybe one of the more interesting sets of cases. And there are several cases where it says, even though there are several prior assaults, nevertheless, still as a matter of law, we're not going to hold the entities liable for the conduct of the person who committed the assault. Compensation as an issue is raping a client, breach of an attorney's fiduciary duty. Why does it matter? I put the title compensation here. It matters for insurance. The victim recovered an assault and battery against the attorney, but if it was also breach of fiduciary duty, then the liability policy would have been triggered, but the court in this case said no. And there are also a number of statute of limitations questions with special statutes of limitations. So a few reflections. One of the questions is knowledge of prior assaults really the right test? The implication is people who have assaulted in the past are going to assault in the future. People who haven't assaulted in the past are going to be safe. You could instead have situational arguments instead of showing the prior bad acts. So one of the examples in a case where a prisoner was assaulted by a guard in the hospital who was guarding her in her hospital room one-on-one, she said, hey, if you can't be one-on-one with someone of the opposite sex in a cell, maybe you shouldn't be able to be one-on-one with someone in the opposite sex in a hospital. That argument didn't convince the court, who said, hey, but this person who was guarding you didn't have a prior history of sexual assault. But in the landowner context, there's actually much broader potential liability looking at situations and not necessarily looking at prior similar incidents. So I come out to a very similar place that Eugene did. And one of the mysteries that sort of stayed with me is we have employment at will. So you can fire someone for not smiling enough at the customers. So if you have repeat complaints of sexual assault, why do we have so many cases where you have multiple allegations, multiple claims of sexual assault? Why aren't firms including the ability to fire in contracts? This is a case from Alaska from 2003 where someone who had 28 times been convicted of criminal offenses, including felony assault, is hired to take care of a developmentally disabled woman who he sexually assaulted. And one of the questions is, why do you have that situation? Sometimes it's low-wage employment. It's who you can get. In this case, the employer is aware and is deliberately focused on the idea of rehabilitation. But some other questions that I have for this and for university process and so on, if you're gonna hire someone who is adjudicated a sexual predator, as in some of these cases and so on, should you give information to the people who are going to be affected by that choice? Judge Posner said the loss of business from telling the truth is a social gain, not a social loss. If it turns out that you have to tell people that you're hiring people with a history of sexual assault and giving them keys to your hotel room and they don't stay at your hotel, maybe that's a good thing because consumers can get more of what they want. And then just a couple other things, and that is the more likely than not standard, which is used in this tort context. People worry that this is going to be toothless. In fact, you see from a lot of these cases that's not true at all. And one thing that I'd love to see is courts talk more openly instead of about rape is not foreseeable in this context or that context, in contexts where it does seem obviously to juries in some of the cases that have given big verdicts, foreseeable. I'd like to see courts more expressly talk about the policy balance of safety and some of these other values.
Okay, I'm going to be talking about how federal anti-discrimination laws relate to sexual misconduct by third parties, including sexual harassment and sexual assault, which is, of course, a species of sexual harassment. But let me first take you through some of the history of Title VII and Title IX. Remember always that they ban discrimination. Title VII also uses the word segregation. Title IX also uses the word exclusion. But those are all related to discrimination. So I think it's fair to say if there's no discrimination, there's no violation. It's safe to say that Title VII's congressional supporters were not thinking in 1964 of sexual harassment or assault, especially by third parties. Of course, that does not necessarily mean that they did not draft a statute that covers it. My point is now that this now huge area of the law would have taken them by surprise. Ditto for Title IX, passed in 1972. On the other hand, if you had asked them about an employer or university that intentionally drives a woman away because of her sex, I think they'd have said, of course that's covered. Otherwise, the statutes would be dead letters. Okay, next stage. Catherine McKinnon and others argued in the 1970s that quid pro quo sexual harassment, sleep with me or I'll fire you, is literally treating a female employee differently than she would have been treated had she been male. And there's logical sense to that. The female's working conditions are very different from a similarly situated male who isn't required to put out to keep his job. The EEOC and the Supreme Court eventually adopted the position that this would indeed be a Title VII violation, and they've also applied it to cases involving gay relationships. It's true that the employer in the hypo that I've given may not have required sex from all women, but it's uncontroversial that an employer who says, I don't mind hiring African Americans, but I refuse to hire uppity college-educated African Americans, that employer is violating Title VII, since similarly situated whites, college-educated whites, would have been hired. Same logic applies in the case of sexual harassment. Note the flip side here. If the employer says, sleep with me or I'll give you a promotion, that ought to be discrimination against any male employee who would otherwise have gotten the promotion. McKinnon and others also argued that sexual harassment can create a hostile working environment, even if there's neither intent to drive the employee away nor a quid pro quo. And in 1986, the Supreme Court eventually agreed in Meritor Savings Bank versus Vinson that this can be actionable under Title VII, but it limited liability to where the hostile environment is, and I'm quoting them here, sufficiently severe or pervasive to alter the conditions of the victim's employment and create an abusive working environment, a high, but alas, very vague standard. One thing Meritor did not emphasize, and I wish it had, is that we still have to be talking about sex discrimination, about someone being treated differently because of his or her sex. So a female employee who's constantly being hit up for sex by her colleagues is in a different, has a stronger case, I would think, than a female employee who's being exposed to the same rough talk as her male colleagues when that rough talk is in no sense directed at her. The Meritor decision did not lead to an immediate deluge of lawsuits. A good part of the reason is that in 1964, Congress, in an effort to avoid jury nullification, allowed only equitable remedies for Title VII violations, injunctions, and back pay. So there was no right to a jury trial. The effect was that only very serious cases were likely to be litigated. Consequently, there was not much pressure to water down Meritor's standard for actionable sexual harassment, the way there often is with high but vague standards. Then came the 1991 Civil Rights Act, which allowed for the first time damages that would account for emotional distress or loss of dignity. And soon after that, we got a Supreme Court case that such damages were also recoverable under Title IX. With Title VII, there was a cap on those damages, not so for Title IX. As all good lawyers know, the remedies that are connected to a statutory cause of action are hugely important as to how that statute is going to be implemented in the real world. Before 1991, an employee who'd been fired for reasons unrelated to sex might ask a lawyer, hey, can I sue for sexual harassment that occurred while I was still working for my employer? And the answer would have been, unless you lost wages on account of it, there's really not much gain to you from it. After 1991, arguably both for good and ill, that changed. Good in that employees who were subject to discriminatory sexual harassment that rose to the meritor level could now be compensated. Bad in the sense that when people are fired, they are often desperate in a way that can cause them to sue for past conduct that didn't rise to the level of the meritor standard. That puts pressure on the standard, and especially since the standard is cumulative, meaning that small, unrelated things like off-color jokes can add up to a hostile environment, employers started to get very, very nervous. We started getting situations like the one where a copy of Goya's Naked Maha was taken down from a university classroom because an employee complained. We got a case where some poor guy with a picture of his wife in a bikini on his desk got ordered to take it down. A CNN poll taken in the late 1990s found that 57% of men and 52% of women agreed, and I'm quoting here, "We have gone too far in making common interactions between employees into cases of sexual harassment." It's during this decade, the 1990s, that vicarious liability becomes prominent. Most sexual harassment is not committed by the employer because the employer is often a corporation, more likely to be committed by other employees. And for the most part, sexual harassers are not motivated by a desire to further the interests of their employer, especially with more severe forms of harassment, including sexual assault. They've usually got their own interests in mind. So applying respondeat superior is very dicey for any plaintiff. Rather than try to apply the often vague respondeat superior doctrines, the Supreme Court in Burlington Industries versus Ellerth and Farragher versus City of Boca Raton held that employers are vicariously liable for supervisory employees who create a hostile environment for someone who reports directly or indirectly to them, but, and it's a big but, unless some tangible employment action has been taken against the subordinate, like they've been fired, they've gotten a cut in pay, they didn't get the promotion, that liability is subject to an affirmative defense. If the employer can show that it exercised reasonable care to prevent and promptly correct any such behavior, and the plaintiff employee unreasonably failed to take advantage of those preventive or corrective measures or otherwise avoid the harm, the employer is off the hook. So when a complainant is not directly or indirectly supervised by the alleged harasser, liability is presumably not vicarious, but again governed by what is essentially a negligence standard that's similar to the affirmative defense that I just described. Did the employer do enough to prevent or correct the problem? All of this has predictably led to an explosion in written sexual harassment policies and training courses. And training courses have become quite a big business as well. It's led to the creation of internal bureaucracies to curb sexual harassment at large employers, along with frequent reminders of what number to call in case of harassment. It has led to a curious restructuring of corporate hierarchies as employers have employees officially report to supervisors who preferably live and work on another planet from their subordinates so that they can't get anywhere near them. In some good ways and in some bad ways, the culture has changed on account of all this. During the same period of time, over on the Title IX side of things, sexual assault tended to take center stage. Sometimes cases are trivial, such as when kindergartners and first graders, kids that can't even spell sexual harassment, much less, sexual assault, are suspended under zero tolerance rules designed to avoid liability. Schools must use reasonable care to correct these problems promptly, and suspension is one way to scream, we are indeed doing something. So general counsel sometimes tell school districts they need to do this. But other cases have been quite serious, and the Supreme Court has dealt with a couple of very serious cases that have shaped the law with regard to liability for third parties. In Gebser versus Lago Vista Independent School District, a high school teacher carried on a sexual affair with a 9th grade girl. The court evidently viewed the teacher as on a frolic and detour of his own, and in a 5-4 decision it held that, I'm quoting here, unless an official who at a minimum has authority to address the alleged discrimination and to institute corrective measures has actual knowledge of discrimination and fails adequately to respond, there's no liability. Since the school district had immediately fired the guy as soon as they found out about the case, that became an easy case for the court. So that's a good outcome for the school district. Another third-party Title IX case, Davis versus Monroe County versus Ed, didn't come out quite so well for the defendant. That 1999 case involved a 5th grader who was harassing the plaintiff, a fellow 5th grader. The school argued, I think with some logic, that it wasn't engaged in sex discrimination. The offending student was. So it should be liable only if it takes sexual assault less seriously than other comparable misconduct. But the court, in a 5-4 decision, responded that Title IX actually says, no person shall, on the basis of sex, be subjected to discrimination by a federally funded school, and that the school, by doing nothing, had subjected the plaintiff to discriminations. Worth pointing out, Title VII doesn't have language like that. But that doesn't seem to have captured the imagination of the court. The court in Davis limited its holding by stating, an action may lie against a school in cases of student-on-student harassment, but only where the school is deliberately indifferent to sexual harassment, of which the school had actual knowledge, and the harassment is so severe, pervasive, and objectively offensive that it can be said to deprive the victims of access to the educational opportunities or benefits provided by the school, which sounds like a very, very tough standard. It would take a lot to trigger Title IX liability, but Clinton and Obama era guidances place additional requirements on schools for student-on-student harassment. The upshot of these documents, these guidances, is that the Davis standard applies only to private causes of action. The Department of Ed has undertaken costly investigations and can cut off funds on a much lesser showing. Knew or should have known instead of actual knowledge. Severe, pervasive, or persistent rather than severe, pervasive, and objectively offensive. Instead of depriving victims of access to educational opportunities, it's sufficient that they interfere with such access. Davis also left open some questions and the void was again filled by guidances declaring broader liability. It wasn't obvious, for example, from Davis that it would apply to higher education, since universities don't have nearly the same level of control over students as elementary schools do. It wasn't obvious it would apply to sexual harassment or assault that occurred away from school, but as the result of more federal guidances, it is now generally thought that it does. I'm going to get in trouble with my moderator here if I don't stop here. So if you want to ask me questions about some of these guidances, that'll work. Thank you.
Okay, if you have any questions, feel free to make your way down and introduce yourself as well as your affiliation. And while people do that, I'm going to exercise moderator privilege, and I want to ask Ellen and Jean a question. So I was interested in the convergence of, Eugene, what you talked about in terms of, second chances, the employer giving someone a second chance and possible liability for sexual assault, and then the slide that you ended on, Ellen, talking about this mystery of employment at will and multiple allegations, and so sort of the collision between rehabilitation and the potential for liability. So I guess as a matter of law, it seems pretty clear that the safe thing to do is not to hire someone like this and to fire quickly if there are accusations. But I wonder if either of you have any views as a matter of policy, how we sort of balance these goals of rehabilitation with also protecting workers and people who've committed sexual crimes are people that we all have to live with, and we're all better off if they can adjust to the rigors of normal life and get working and become productive members of society again. So I just wonder if, as a matter of policy, if either of you have thoughts about that.
Ellen, you first.
Let me try this. I think that we probably come out in a little bit different direction. And I would say a couple of things. I think there really is a trade-off in a number of these cases that you see quite clearly. One case in Iowa of a sexually violent predator declassified from being a sexually violent predator and put into like a nursing home because he had dementia, and then he was assaulting people in that home. And I think that it is a balance. There are potential safety risks. Part of it depends on what's the likelihood of someone reoffending. In that case, there were experts who had testified before the placement that they thought it was a bad idea, and there was a high likelihood of reoffending without some kind of supervision. So I tend to think, you look at different kinds of situations where employees can be fired for all kinds of things, and I think, this is a pretty legitimate reason for firing someone. If you have complaints that one of your employees is harassing customers, harassing students, and so on, I think you have to be pretty concerned, not just about the liability, but about the interests. Now, if you really want to structure and supervise and figure out the way that you make that not happen again, great. The other thing to be aware of is this is just a liability rule. Right? So if you really think, hey, this happened last time, but it's not going to happen again, great. As an employer, take your chances. But you are taking your chances, and if the person reoffends, there's a liability rule, and that's going to be your cost.
So I'm not sure where I come down on this. I think this is a hard question. Let me just tell you descriptively about one case, which is interesting because it actually adopts what sometimes tort law does in this area, is a no-duty rule that says basically you don't have a duty of reasonable care when it means you can't deal with people with criminal records. And that's Eisman v. State. It's a 1987 New York case. I think the 80s in New York may have been a more rehabilitation-friendly time than, let's say, the 2000s were. Maybe where the things are going back towards more focus on rehabilitation. But what happened was this guy, Larry Campbell, 1972, I mean, actually it was the 70s more than 80s, pleaded guilty to various crimes, drug crimes, but also they involved some degree of violence. He was released in 1975, and there was actually a program at State University College Buffalo, which specifically tried to take people who are out of prison and kind of preferentially admit them to make sure that they got an education to keep them from going back to prison. Well, maybe it works for some people. Didn't seem to work well here. He basically murdered several of his classmates, and I think raped at least one of them. So the injured people and the heirs of the dead people sued, and the court said, look, we're going to announce a no-duty rule because we don't want to put universities in a position where basically they're told, if somebody has this kind of record, you just can't let them in, and that's it. They're never going to get another education. At the same time, that isn't always the rule, and you have some situations where in employment, for example, it started out with particular areas of employment, like, well, you shouldn't send people into people's homes the way that, let's say, utility installers might be or some such. But unsurprisingly, given the nature of the tort liability system as a common law system, it's ended up being extended by analogy. So the example that I most have in mind, except for the case name, I think it may be Mahoney, is an Illinois case where somebody who had a sexual assault history was released from jail and was hired as a trucker. And what happened is he picked up a hitchhiker and then raped her in the sleeper compartment of his truck. And the court said, well, you, the employer, could be held liable because, after all, truckers, they have these sleeper compartments which can facilitate these sex crimes. But once you get to that, the question is, what job wouldn't in some measure potentially facilitate it? What if he wasn't a trucker? What if he was driving a van? Well, he could have sex in a van. What if he was driving a car? Well, he could take the car and drive it to a secluded location. So the problem that arises here isn't just somebody loses a job. The question is, what job could they have? Because if there is a cause of action for negligent retention, the same thing would apply to negligent hiring if the employer knows anything about that. Likewise, I don't know to what extent this has been done in Title IX, but under the logic of Title IX, if you have a duty to expel someone because they pose a risk to their classmates, you would logically have a duty not to admit them in the first place. Likewise, let me give you one other case, Giggers. It's a Tennessee Supreme Court case, I think, unless it's Kentucky. It's one of the Tennessees. Oh, sorry. So it's, in any event, I'm sorry, it's Memphis, so it's Tennessee. And what happened was that Giggers had threatened some co-tenants, and then he actually shot and killed a co-tenant. And the court said the housing authority is liable for not evicting Giggers. Question is, where would Giggers live? He's got to live somewhere, right? And maybe you say, okay, fine, he's got to live under a bridge, but it's not like that's going to materially decrease the aggregate risk of society. It may decrease his risk to his co-tenants because he doesn't have co-tenants, but it may increase his risk to others if we think that people who sort of feel they have little enough to lose will be especially likely to commit further crimes. So the thing that brings me around, and I'm not a very strongly pro-rehabilitation guy, but the thing that brings me around to sense there's got to be some limits on duty is otherwise you get people who basically, it is risky to ever employ in any position. It's risky to admit to any university program. It's risky, or vocational tech program. It's risky to provide any housing to. So one possibility might be, for example, in the employment context, look, have a set of rules, have a statutory list, have a big table that says if you have this kind of conviction, you are ineligible for this kind of job. But at least provide employers with a certainty that, well, if it's some other job, you can try to give this other person a chance if you're willing to run the first party risk that he may attack you or steal from you. Because if you don't do that, then again, the question is, who is going to hire them? Are we really letting someone out of prison saying, okay, fine, you're out of prison now, but basically you've got to understand that because of the tort liability system, nobody smart will ever give you a job. Nobody smart will ever give you a place to live. Nobody smart will ever let you in for education.
Okay, I just wanted to make a point here that there's kind of a damned if you do, damned if you don't aspect of this. While on the one hand we say, okay, you may be in trouble for hiring somebody who has criminal background because you knew this person could have caused a problem. We've got guidances coming out of the EEOC that are going in just the opposite direction, saying that you cannot exclude an employee under some general rule of we just don't hire people who've committed crimes. And it is a guidance that is extremely vague. So if you're an employer and you're looking at this guidance and you're trying to avoid a lawsuit, you got to be really, really careful. For one thing, they tell you that you shouldn't ask someone up front front whether they have a criminal background. You should decide which of the applicants for the job that you want, and then ask. So what you've done is you set yourself up for a lawsuit because the person knows that they came in first in terms of who the employer wanted to hire. And if they don't get hired, then they know it had to be that they, in the end, they disclosed that they had a criminal conviction. And the guidance is so very difficult to interpret. And they even go so far to say, even if there is a state statute that says you may not hire someone for this category of job who has this category of criminal conviction, they say, hey, supremacy clause, you got to go with our crappy little guidance instead of the statute. And so it's very, very difficult on employers. I myself am a fan of, and I'm not usually a fan of these things, I am a fan of the tax deduction that the federal government has for people with criminal records. It's one of those things where an employer can decide based on the particular applicant, the particular crime, and the particular job, that this is a risk they're willing to take. And, maybe there is room for
I'm sorry, what's the tax deduction? I don't know about it.
You hire someone who has a felony conviction, and there are circumstances under which you can get a special tax credit or tax.
Oh, tax credit, because his salary is tax deductible regardless of whether.
Yeah, but there's something additional. I don't know how much it is. It's hard to gauge exactly how much. How much of a bump should you give somebody? You don't want it to be so great to where we're all running out looking for like the worst possible criminals to put in jobs, but like a little bit of a bump, that strikes me as a lot more sensible than the EEOC's approach to this.
I wanted to ask two things. I did want to invite Gail to give some more guidelines that she wanted to talk about in her talk, but I also want to ask what the sort of catch-22 problem for employers is highly undesirable for society. I mean, you don't want to put an employer in a situation where, well, if I hire this person, I get sued. If I don't hire this person, I get sued, et cetera. So how does one address that effectively without, I mean, I don't know about encouraging recklessness because if you, I'm picking the example where you're really, stuck either way. But how does one address that?
Gosh, I wish I knew. It's very difficult with the EEOC guidelines being the way they are on this, and yet the very problems that we've been talking about here. I mean, I agree with Ellen that these are balancing issues, and yet for the typical employer to know what to do when they've got Title VII with criminal background checks issues, and then Title IX and Title VII with regard to sexual assault and other kinds and tort liability. It's very, very difficult to know what to do. I thought that I had like a very, very simple solution to just a little piece of the problem, and that was that Congress should pass something that simply overrules the criminal background guidance from the EEOC with regard to those cases where state law actually requires that they not hire somebody. Because I thought, okay, just classify that as business necessity as a matter of law. But like they held a hearing on it, but ultimately members of Congress were not willing to do anything. Didn't want to create controversy, was afraid this would be represented in the press in ways that didn't thoroughly explain it, and so people would think that it was an attack on people that are just trying to get a break after they get out of prison. So it's not easy. One more point I wanted to make about Title IX was that, a lot of times you will hear people argue about the Obama administration's, what they refer to as sexual violence guidance, the one that was recently withdrawn by the Trump administration. And one of the things you would hear argue is that we don't really need all that much in the way of due process because all you're doing is taking someone out of school, and it's not that big a deal. I mean, they can go somewhere else, but they can't. And there are plenty of cases where the facts of the case, I think, are very sympathetic to the male student who was expelled. And You know, it looks to me like they have defined sexual assault way beyond anything that I think is appropriate. And yet it's very difficult for a student like that to get into another school. And a lot of students have had very difficult time with that. So it is a big deal to be thrown out of college because you're unlikely to get into another college easily, much less a college that is as good as the one you got thrown out of.
Ellen, I'm wondering what do you think sound policy ought to be? And maybe, you know, the answer is actually, it's very different what's politically available. But what's sound policy? Let's assume somebody even has a criminal history. So somebody has a serious violent offense on his record, say a sex crime, and now he's coming out of prison. And imagine, and now we have even better record systems than ever before. So actually a landlord, and maybe there's some schlocky landlords out there, but a landlord that sort of is professionally organized, just looks up and says, ooh, there's that, and I hear about somebody who was sued for renting to a tenant who had committed this kind of crime. Or if those are unusual, and it's true that the landlord lawsuits are unusual, so then the employer says, well, look, you know, somebody was sued, the trucker was sued, obviously the home care person is sued, but even, you know, I may be hiring the guy from McDonald's, but you never know. It's going to be late one night. It's going to be the only employee, the only customer. The person attacks the customer. Now I'm going to get sued. How do you avoid a situation where basically we let these people out of prison? We're hoping they're not going to get back into prison. We're also at the same time making them unemployable.
I guess I would say a couple of things. The first is I wish that in these cases full information would be given. So a lot of the cases, you know, no information is given by the agency with the foster child to the home that there is an issue that needs to be addressed, or no information is given. One of the 2017 cases is a welfare to work program. The welfare to work program doesn't accept people with a criminal history, and the state says, oh, here's an appropriate person for you, and doesn't give any information that there is a criminal history. Now, I think that in terms of making a plan about what's appropriate supervision, about what's an appropriate role and responsibility, you need to have more information first. And then I think the question is about, you know, what's the nature of the job? So the caretaker of a young disabled girl who has keys to her apartment, that's the kind of thing that I think you want someone that you have a high level of trust in. But, you know, you could be at a call center. We've got a lot of those in Arizona. You could be at a lot of different kinds of jobs. But I do wonder if more information and more of a plan about what's appropriate level of responsibility, and also, you know, what's the potential for the risk. And I think in a lot of different cases, they're quite different in terms of what's the risk of recidivism.
But I'll bet you that if we were talking some years ago and somebody said, well, what about for long distance trucking? Do you think that would be a safe job to hire somebody for? Probably most of us would say, yeah, sure, it's not like this person's going into anybody's home or whatever else. But of course, along comes this case. The jury and the judges are more likely to side with the horribly injured plaintiff than with the company. So the problem with the tort law system, the way it operates, it seems to me, is that there's no safe harbor. It's not like an employer could say, I just don't have to worry about hiring this person for this job, because there's always the possibility that something will arise, either with regard to coworkers or with regard to somebody else. Isn't the rational thing for the employer to say, the moment I hear this, then unless there's some other risk, either some state law that barring discrimination, or I'm governed by these EEOC guidelines, but because of the size of my operation and such, just the only safe thing to do is just say, no, I'm not going to hire this person.
If I may, I just wanted to add one thing because it's directly related to what
Yeah,
you
please,
just
please.
said, which is what we haven't talked about yet, since we're at a Federal Society event, is a lot of state laws have gone the other way and done ban the box legislation.
Right.
And so we haven't talked about that, and I wonder whether that does operate a bit like a safe harbor, because if sort of you can't ask, then doesn't that sort of have the effect of a safe?
No, but the ban the box legislation, I understand it says you can't ask up front, but then once you know that this person that you're about to hire them, then you can ask for their permission to do the background check. Refuse to hire them if you don't give the permission. If they do give the permission, you do the background check, then you're back where you started, except maybe subject to more EOC risk. Now, some states, I believe New York, Wisconsin, and Hawaii, actually have statutes that ban discrimination based on criminal record. But unsurprisingly, since nobody thinks you should never discriminate based on criminal record, what they do is they've set up these mushy 15-factor, I think literally 15 or so factor balancing tests that also don't give employers any information on this.
Right. And then on top of it all, since there's obviously a disparate impact on the basis of race, and there's all the litigation that says that sort of looking for criminal records sort of has a racial impact, and so you might face a disparate impact claim under Title VII as well.
Well, I think that depends on the circuit.
Right.
But actually, I'm sorry, Ellen, I want to make sure you have.
I mean, it doesn't bother me to say to an employer that you have to worry about this. I think it's a completely appropriate subject to worry about. I mean,
But but doesn't that mean that basically you release someone out of prison and they're basically largely unemployable? Which, if that meant, well, too bad, you committed your crime, you're going to be damned to a life of penury. Well, sorry. Yeah. But the problem is, they're going to, if I'm right that somebody who is released from prison and who doesn't get a job is more likely to attack someone, you may not be actually decreasing the overall crime rate. You might be increasing it. You might be sparing the people who might otherwise be attacked by this person when he gets the trucking job, but you might then be victimizing people who are attacked because he's a passer, they're passing by the homeless encampment or whatever else, and he attacks them. So what do you do about the problem that if this is taken seriously and if employers are all become super rational and knowledgeable, the consequences seems to be nobody gets any jobs? I mean, nobody who's got a criminal record.
I still like the tax deduction. You know, I'm usually not for these things.
So I looked it up. It's a $2,400 tax deduction, tax credit, excuse me, for people who hire ex-felons within a year after they're convicted or released from prison.
Yeah, the nice thing about it is, you know, it's clear who's in that category and who isn't. So this is something that can be done through the tax code. You know, you can argue about whether it should be greater, whether it should be 2 years, you know, all sorts of different things. But I still think it's a good idea. Whereas most interesting things in the tax code I don't think are good ideas.
Ken Simons from UC Irvine. I had a question about what's in the news these days about sexual harassment and an awful lot more publicity being given to it and prevalence of it being much greater than many of us had realized. But one aspect of it that I think affects the balancing that many of you have been talking about is the public relations aspect of it. At least in high visibility jobs, is there a worry that employers will overreact and fire workers or eliminate their jobs based on even lower probabilities of actually having committed wrongful acts than liability concerns alone would justify? And maybe that's an exaggerated concern, but given how rapidly they've responded in some of these cases and replaced people on films, et cetera, and given that we don't know all the details of some of the accusations, is that something else that should be balanced? And again, maybe it's only a very narrow worry in terms of high visibility hires, but this may extend to other cases involving lower level employees, where if the word gets out that someone was not fired, it would very seriously damage the reputation of the company.
Let me take that. I think, I guess I'm not as worried as many of the other panelists, and I suppose for a couple of reasons. One is with a background of employment at will, you can fire people for any reason. And so it seems to me that firing because, you know, someone did some creepy things, even if they're not actionable harassment, for example, is okay. And we've had a lot of discussion in Tucson the last couple of days. We've got firing around us, and you know, who knows what, if the allegations are true, not true, but you know, one of the allegations is that coach is walking around in his boxers at work. And, you know, you could fire a coach for not having a successful season, which was the reason our last coach was fired. And you could fire a guy for walking around in his boxers at work. And I'm not necessarily more concerned about firing the guy who's walking around in his boxers than firing the guy who's not winning.
Well, I don't think the law has much to say about the particular problem you identify, except insofar as some of the charges with their false and defamatory, one traditional role, albeit of course quite limited for libel laws to prevent that. I will say that employment at will, I'm a supporter of, but one of the reasons is, you know, somebody's fired by one job, if it's for a really silly reason, it may make it a little harder to get hired at a different job, maybe even sometimes a lot harder, but many times the employer will say, look, you know, it's their loss. The new employer. It's the old employer's loss. They look really good. You seem to have done well in your probationary period. We'll give you a chance. When you have a legal liability system, this is shifting away from your question to be sure. When you've got a legal liability system that puts all employers who hire this person on the hook, then it seems to me it's more than just, well, too bad for you, employee. Employers could just on their own refuse to do business with you. It's more like, well, we're telling employers that it's very pricey to do business with you. And that doesn't seem to me to be quite the same as employment at will. One analogy, and I realize it's an imperfect one, but in many states it's not illegal to fire someone based on their political views. In some states it is, it turns out. More states than you'd think. California, for example, it's illegal. Louisiana, South Carolina, various others. But in many it's not. But I think it would be a different matter if the government were to say, well, if you hire someone with certain political views, then we're going to expose you to more legal liability. So the fact that we allow private parties just to do this doesn't tell us, I think, that much about what it is that the government, through threat of liability, should be doing.
I guess I'd have to say that employment, I also believe in employment at will. I think it's a good thing in many contexts, not all contexts. But it's the problem here. It's not the reason that it's not a problem. It's the problem because employers feel like they are going to be pressured to sue, to fire the person when they otherwise wouldn't want to. But there's the threat of litigation on the other side. The Google case, I think, is kind of an interesting one. It's not a sexual assault case, and it's not clear exactly why Mr. DeMoore was fired. But the document that he wrote was not a misogynistic screed. It basically said, hey, here are some ways we might be able to help attract more women to Google, but we shouldn't assume that simply because there are fewer women that want jobs as software engineers, that it must be because of bias. It may well be that women are more interested in more people-oriented jobs, and there's plenty of empirical evidence to suggest that that's the case. And one of the arguments that was made for why he had to be fired was that this was, in fact, a case of sexual harassment, and if he wasn't fired, that there may be hostile environment cases. I mean, that strikes me as extremely troubling for reasons that Eugene was just hinting at here. It's the case that an employer can have all sorts of speech codes, can say that, like, you can't speak at all while you work for me. You just have to be quiet, never say a word. Or you can only say, the following 8 words. But it's a very different thing when it's the federal government that is telling the employer indirectly that if one of your employees says this, then you could be on the hook for liability. So it's very dangerous.
And let me just add in tort, I think it's a little different. It isn't the federal government. It's just what does a jury think is reasonable in a lot of cases, to the extent that courts let it go to a jury. And I think sometimes we have to think about what is an appropriate consequence. Like if you do something that's a crime, for example, one consequence is you're going to go to jail potentially. Another consequence is it might be hard for you to get a job afterward, and that might be a consequence of your own conduct. I think we also have to look at what really, I'd love to see empirical evidence about what really happens to people in different situations, like to people who in a university setting are expelled for a period of time, or what happens to rape victims where the person isn't expelled. I think it would be interesting to have some real empirical evidence. Is that really the end of the college career, the end of college, the end of a career, et cetera, or is there more resilience in some of these processes?
Hi, Lee Leber-Benotis, the Senior Vice President of the Federalist Society. So it's a bit of a puzzle. I mean, I think it's very likely that no matter what the law is, you're going to have a lot of problems, I guess, because I think one thing we're seeing is that even when we did have, you know, this legal regime that's creating, you know, apparently some of these potential pressures, you know, that it wasn't working very well to root out the things that people were really worried about in a lot of circumstances, because just the difference in the power dynamic was such that people were behaving very poorly anyway, you know, because they wanted to, and you know, these things are, you know, and yet at the same time, you know, there are problems. It may well be that the law was also, you know, creating other kinds of problems with you know, people who weren't behaving badly, and so I guess I think it does seem to me that the law is a somewhat imperfect tool here, I guess, and I'm wondering what other tools there may be that might be of some value, that might be worth thinking about.
I think information. I really think coming back, I mean, some of those university guidelines that we all have to disclose different kinds of crimes on campus and so on. Shopping malls, for example. I have a student who was abducted from a shopping mall near me at gunpoint. I had no idea. I had never heard of it. And I do think sometimes if you want people to be able to make appropriate choices, giving more information would be one way.
So I wrote an article a couple of years ago called Tort Law versus Privacy. And the question was, to what extent does tort law does not promote privacy the way privacy torts are supposed to, but to what extent does it actually undermine privacy? Possibly correctly. It's not like I'm a huge fan of privacy writ large. There are real costs to privacy. But if you really do take it seriously, I mean, you can imagine the following informational regime. If you hire a sex offender, you must put up a big sign. We are hiring a sex offender. And, you know, I could imagine that being a possible argument. And in fact, some sex offender registries are all about that, although it's usually not kind of point of interaction. But then you shouldn't pat yourself on the back and say, well, we're solving the problem because, after all, we're not actually holding anybody liable for hiring. We're merely hiring sex offenders. We're merely requiring them to prominently announce this to the world. You still have this question. And this question, by the way, comes up in other contexts besides tort law. I think a lot of states are trying to decide to what extent should public records be expunged some years after a person's criminal term is set up, and to what extent they should be after the term is finished, and to what extent they should continue. But one thing to keep in mind is disclosure regimes, when they go beyond just the disclosure of what happened at the entity. There have been attacks at this university, there have been attacks at the shopping mall, and require actual disclosure about a particular dangerous person, you know, you have to accept You have to reckon the cost of privacy there, and maybe we shouldn't care, especially if it's privacy of people with criminal histories. You say, well, too bad, you committed the crime. You should have known that the whole world will now know and will know indefinitely. I totally understand that impulse. It just seems to me that there are going to be real indirect social costs as a result of that.
And the flip side of that, given what we were talking about earlier with what's been in the news, is the enforcement of non-disclosure agreements in settlements in these areas. So many of these cases that were brought forward, the company will settle, there'll be a non-disclosure agreement, and therefore nobody knows that so-and-so has
This is true.
sexually assaulted.
This is a one cost of non-disclosure agreements.
Right, so to what extent should those be enforceable, not enforceable? How do we think about it?
Right, although the interesting question also, it's a similar question to some of the things we're talking about, which is, do we care more about the crime victim who is the plaintiff, or do we worry more about future crime victims who might not be? Now, sometimes the interests of the two go hand in hand to the extent that you think that liability will cause deterrence. On the other hand, if you're a lawyer representing a plaintiff, surely one very valuable asset to you is the ability to have the plaintiff sign a non-disclosure agreement, and and the defendant will say, okay, fine, we can either make the case go away for this pot of money, or have the case and have it all be quiet, or have this case be widely publicized, even if we ultimately win. So if you favor tort plaintiffs, if you favor compensation for victims, it's an interesting question what you should think about those kinds of non-disclosure agreements.
Maimon Schwarzschild from San Diego. There was in medieval English law a penalty of outlawry, which was thought to be at the time sort of worse, if anything, than capital punishment. And the idea of outlawry was that if you were outlawed in that sense, nothing that could be done to you by anybody would be a crime. So you could freely be assaulted, you could freely be murdered, you could freely be robbed, whatever it was. You were outlawed. You were no longer protected by the state. To some extent, what has been described here looks a little bit like that, potentially at least, for people seeking jobs, people seeking people with any sort of record, seeking a job, seeking someplace to live, seeking education. And I guess the question is, a couple of questions arise from it. And everything is sort of interlocked to some extent. One is the question of the availability of information. Under a non-internet regime a few decades ago, the chances were that if you had that kind of background in state X and you went to state Y or state Z, nobody would know about you, and these...
I'm sorry, this is America. We don't have state Zs.
Wherever I go, we have state Z. The information regime has obviously changed, so even if you go to a state you stay in a country with Z, or you go someplace else with Z, the information is going to follow you. And likewise for all these other benefits. So one question is what the implications of the new information regime are for these considerations. The second question, I guess, is whether the creation of a kind of outlawry is like, what the implications of that are likely to be. One possibility is that employment will simply, it will be one more drag on employment. If I'm an employer and I'm told I have potential liability for hiring somebody, I also have potential liability under various non-discrimination laws if I don't hire somebody, a robot begins to look very good. And that's not just true at McDonald's, but that's true in a whole variety of possible employment contexts. So is that one possible implication? A second is this. The Supreme Court has said that if I am convicted of a sex offense, which I've got to be convicted of beyond a reasonable doubt, once I have served my term, I can still be kept locked up on something very much less than beyond a reasonable doubt. So I'm outlawed out in the outer world. I'm potentially going to be held in protective custody after I've served my sentence. These begin to look like ferociously medieval penalties. Is there going to be a reaction against that at some point, or an overreaction against that at some point, as there were against what were felt to be overly cruel medieval penalties? So that's a variety, I suppose, of questions and of thoughts for various of you.
Well, I got an email, this was some years ago, but your question made me think about this again. You know, many states have these laws that say if you're a sex offender, they're going to put something on the internet. And this was a young man from Georgia, and he had been convicted of statutory rape. And you will recall from law school, if you haven't thought much about the crime of statutory rape, that it's a strict liability crime. So what had happened was that he had been at a college party, a good friend of his, and the sister of the friend, who was actually a high school student, was at the party. And he had no idea that she wasn't a fellow college student. And, you know, one thing led to another, and the two of them had a sexual experience. The father of the girl found out, and there was a racial element of this. The young man was black, the high school girl was white. The father threw a fit and insisted that the police prosecute, and in an earlier day, a strict liability standard like that would not be the worst thing in the world. But it is now. He did not, I don't believe he served any time in prison for this. But, you know, the father was high up in the police department, and hence had some clout on this, and did manage to get the kid convicted. And he couldn't get an apartment, he couldn't get a job. And he wrote me, like, can you help? And the answer was, well, not really. I sure would like to. You know, I blogged about it. But the punishment, at the time that statutory rape was defined to be strict liability, you know, that was something that was tolerable. But now the punishment is way disproportionate. He had no idea that she was not an adult.
So I'm not terribly opposed to sexually violent predator terms in practice. I just think maybe the better way of putting it would be you could have, especially for sexually violent predators, that's not statutory rape, could be a life sentence. If you want to lock someone up for life for a serious sex crime, I'm not in principle opposed to that. What troubles me is we do actually let these people out, and then the question is what to do with them. And some of it may be that they're unemployable, some of it they're employable only because of a crapshoot. That the only reason why this isn't a worse problem is there's some employers who are not thoughtful enough and are kind of reckless about their own possible liability, and maybe their insurance carriers aren't demanding enough. And, you know, so maybe the consequence is that things aren't as bad as they are. But one thing that I ask about with a legal rule is, what would things look like if the legal rule were really enforced? And if the only reason it's tolerable is because it's under-enforced, something a sign against that legal rule. But I will tell you, and this is what I was looking up, I'm happy to report that the Texas Constitution specifically says that no citizen shall be outlawed. So, so if you're worried about that, Texas is your state.
I think also part of the problem here is that there are very serious sex crimes, and then there is the current trend towards calling everything rape, which has been very destructive. And, you know, we need to concentrate on dealing with serious sex crimes and also dealing with other sex crimes and other sexual misconduct, but not calling everything rape.
So I think that's right, and I also think that one has to. The fact that some of these rules have been defined too broadly doesn't necessarily tell us that the rules having to do with notification and such are necessarily bad. But part of the problem is in the sentencing system, and in Megan's law system, we could easily say, look, we're just going to exclude statutory rape when the parties are within some number of years of age of each other, or when it's strict liability or whatever. You could do that. Part of the problem is, traditionally in the tort law system, we haven't had sharp rules like that. So we don't know. If an employer comes to you and says, you know, there's somebody who was convicted just of statutory rape, and I'm wondering if to hire him to work at McDonald's, and you know he was 19 and she was 15, so it's not like he's a 40-year-old, and now he's say 25. What would you tell the employer? Would you tell the employer very, very high risk? No, probably not. Would you tell the employer, go ahead, it's safe at least from legal liability? I don't think you'd say that either. That's part of the problem. I'm sorry, Ellen, you were...
Well, I'm just thinking from what you said, I'm not sure that's the problem. I mean, I think that's okay to say to the employer, it is a liability rule. You can hire that person. If you want to take a chance on that person, take a chance on that person. If you think that this person has changed and you're right, you will have no liability because it's only if there's this second harm. Even if there's this second harm, we're talking about it as though it's a given that if there's a second offense that the employer is going to be tagged with it. That's certainly one factor, but those other cases that maybe I didn't have enough time to really develop, there are several times where the courts can say, what I wish they'd say is, as a policy matter, weighing policies of reasonable care and safety and other values like rehabilitation, we find there's no duty, or it goes to a jury. And we're talking as though a jury can't be convinced that this was reasonable by the employer, but actually you could argue to the jury that the employer's behavior was completely reasonable, or that the misconduct was outside the scope of the employment, or something else. So I think we're very far from this kind of strict liability if you hire someone again, but I do think it elevates your risk, and maybe I'm more of a fan of the situational approaches where that is just one factor, but in some cases that might be appropriate. If you know of someone with a history of violence in a certain way and you give them an opportunity, then it may be appropriate to be a little bit more concerned about your supervision of that person.
So I should say, I certainly don't want to at all suggest that there's strict liability here, or these cases are even necessarily easy to win. My guess is probably, like with most cases, a lot of them ended up being settled. But the problem with the saying leave it to the jury is, again, the employer comes to you and says, here's the situation. Kind of, in my heart, I would like to give this person a second chance, but not if it means there's this extra risk of liability. Can you tell me that there is an extra risk of liability or that there's no extra risk of liability? The honest answer is there is an extra risk of liability, and the fact that maybe the jury will say that you're okay isn't going to help the employer.
Yeah, can I pick up on that, Eugene? Because it seems to me that if you're employer in most situations where you have some, it's not your own, if it's your family business or your own business, and you're responsible to no one but yourself, that's one thing. I want to take a chance on this person, I can. But I mean, for most people, they have fiduciary responsibilities that are pretty significant to their organizations. It's not really entirely their choice. And it's completely irresponsible to take a 2% chance. You've got a real problem here, and you get sued, and you might have to pay out a huge settlement. You may want to, but it's just not a responsible thing to do, which means, as an economic calculation, it means people aren't going to do it. So the question is, how do you get around that problem? That's the way to look at it.
I mean, the one thing I can add in here is, boy, in these cases, a lot of people are doing it. So somehow people are getting around that because, I mean, I was shocked to see the one with the 28 offenses convicted. Here are the keys to this girl's room. I mean, that was, I think, extreme. But you do see a lot of cases where the technician at the hospital, one of the 2017 cases, assaulted 10 or 12 different women who are suing together. So I think that, some of these cases, and part of the problem, actually, if you think about what's best for that individual who is the assailant, sometimes it is not to give that person the opportunity, because some of these people are ending up life imprisonment after that crime is committed, in addition to having the employer or whoever have the tort suit.
Well, there are a lot of managers who are fools because there's a lot of everybody who's fools, right? so there are always going to be people who end up not kind of following the deterrence logic of the law. And sometimes we might say, well, it could actually be fortunate because that means that
the law is not perfect at basically making people with criminal records unemployable. But if the only reason that people with criminal records can get any job is that employers out there are some of them who are fools and therefore are willing to run the risk, or maybe a very few are aware of the risk, but they run their own companies and they say, I'm going to run this risk and I'm going to do this calculation and I trust the jury, then again, I think you just wonder, are we creating a safer society this way? Or are we creating a more dangerous society? And I actually don't know the answer. But I do think that once you let somebody out, you want to think a little bit about the incentives that you are creating. Now, again, it sounds like at least, I look up, New York at least has this credit. Maybe the federal government sounds like does too. So we are creating this incentive, but then we have to look at what the contrary incentives are.
Brad, if we're out of time, I'll yield.
We still have like a minute.
Okay, all right. Anthony Dierter, Federalist Society. So with respect to universities in particular, is there kind of a tension there that's not present with respect to other employers because of the nature of the commitment to sort of free and open inquiry? And just to sort of flesh that out briefly, I live in a Midwestern town with a large state university, and you know they have sex fairs. It's kind of very open and explicit. People attend these. And the overall environment of that sort of encourages a lot of sexual experimentation, et cetera. And I mean, maybe it's just me, but that always seems somewhat in tension with the sort of concern about resulting sexual assault, et cetera. In fact, at the same university, you cannot enter really a bathroom stall anywhere on campus and not see a paper talking about how there's sexual assault. Here's numbers you can call. Has someone been injured? Here's sort of the consent is important, but they never quite explain what consent is, which is interesting. But does that sort of tension between this sort of active sexual environment and yet at the same time, people talked about these fairly strict standards of liability in some respects, sort of create a unique problem for the university, and is the law really able to kind of account for that? I mean, maybe I'm just talking about a correlation that doesn't show causation, but I'm curious.
I mean, do we have any data that suggests that these sex fairs, whether one thinks they're kind of vulgar or not, or over the top or not, whether they're actually more likely to lead to sex assaults? I mean, I'm not sure at all that they would be.
Universities are bipolar these days. It's this won't end well. What's interesting is sort of to compare it back to an earlier time. In my grandmother's time or my mother's time, universities would have lots of rules about the contact between males and females, designed to head off problems before they occur. We had prophylactic rules not to use them. I shouldn't have used that. We had rules that were designed to prevent problems from arising. And if you bring that up in front of students today, they will go berserk. They don't want rules that say we don't allow males in the girls' dorm after certain hours, or we require both feet on the floor if you're in the room. And yet, to me, these rules were perfectly sensible. I don't want to wish them upon students who don't want them. But it is odd that we have this culture on campuses now that are, on the one hand, very Title IX oriented, very, very fearful of sexual assault, which is indeed a problem, but at the same time, libertine in other ways that seem designed to create problems.
Can I end on a positive note? And that is, I have two boys in college in California, and there's all these issues swirling around, especially with California and affirmative consent and so on. And I talked at length with my older son about all of this and what I'm going to talk about and so on, and what are the ideal answers. And he said, Mom, I think the Title IX offices at college campuses are great. He was head of a house, like a residential house, and worked with the Title IX department in that way, and they came in and did programs and education. And I think both my kids have no fear of any kind of liability. And I think, different colleges have different environments, and they're both lucky to be at good places. But I do think for some of this, they're sort of working it out. I mean, it's different from what the expectations were when we were younger, and but I do think that a lot of the kids think things are working just fine.
I have spoken to, I can't tell you how many young men and mothers and fathers of young men where the rule is that they don't go anywhere near a female on their campus. And that is just their rule to avoid liability. They will date women from other schools, but not from their own.
Do you think they actually do that? I mean, again, this may be a situation where it's the rational thing to do, but I just wonder whether that's the way.
Yeah, I just go on what they're telling me.
All right. Well,
okay.
that's
Well, join me in giving our panelists a round of applause.